paper analysis for the 27th of March 2024. Now let's quickly proceed and have a look at what do we have to discuss today. So for the editorial segment, we have an Indian Express article which is titled as this: Why did the Supreme Court refuse to stay the appointments of 2 election commissioners? So I'm sure by now all of us know that for quite some time there has been a back and forth going on between the judiciary and the government with respect to the position or the process of appointment of the Chief Election Commissioner and the Election Commissioners of India. So now this is a recent development in this matter, and by using this article, we will be in a position to understand this entire, trajectory of events. कि पहले क्या process था, फिर बाद में क्या हुआ, then what is the current process and position. So this is going to be very important. Secondly, we talk about the important news updates for the day. And lastly, we have a look at the legal news. So let's quickly head and start with the article. So before we have a look at the context and start with the current development, I think it would be easy for us to understand if we start with the facts from the very initial. So election commissioners and chief election commissioner, उनको appoint करने का जो process है, उसको समझने के लिए हम 3 stages में बात करेंगे. पहला is the stage prior to the pronouncement by the Supreme Court of its judgment in the landmark case of Anup Baranwal versus Union of India. Then secondly, we talk about the position that the Supreme Court proposed in the form of an interim solution for the appointment of these commissioners. And thirdly, we talk about the current position by virtue of a December 2023 law. See, prior to the pronouncement of the judgment in the case of Anup Baranwal, the Chief Election Commissioner of India and the election commissioners, they were appointed directly by the President on the aid and advice of the Prime Minister. तो यहाँ पर हम कैटेगोरिकली देख पा रहे हैं कि जो सुप्रीम कोर्ट उसकी कोई इंटरवेंशन नहीं, एज इन जुडिशरी इज नॉट इन्वॉल्व्ड हियर. Here there is just the involvement of the current government. Then came the judgment in the case of Anup Baranwal versus Union of India. See, in this particular judgment, a 5-judge constitution bench of the Supreme Court, it modified the process of appointing these commissioners. The Supreme Court ने propose क्या किया? As an interim solution, the Supreme Court constituted a committee comprising these 3. Who are they? The Prime Minister, the Leader of the Opposition in the Lok Sabha, and the Chief Justice of India. So here we can see that the composition of the committee is such कि 3 divisions से लोगों की representation हो रही है. As in, we have a person who is voicing the opinion of the government. We have a person who is voicing the opinion of, let's say the opposition. We also have Honorable the Chief Justice of India to represent the judiciary, so to say. So therefore, this is a very democratic sort of a composition of the committee. Now the bench, it also noted that Article 324, Clause 2, it places an obligation on the Parliament to enact a law for this particular purpose. अगर आपके पास थोड़ा सा टाइम है, तो then you can go ahead with the reading of this particular judgment. It is very important because यहाँ पर Supreme Court ने at length discussion करी है कि how it is very important for a democracy to thrive that the election which is conducted for the purpose of choosing our representatives, it is fair, it is just, and without any sort of favoritism. And here, therefore, it becomes all the more important that the election conducting body, it is impartial, and it is not functioning under the control of, let's say, the ruling government or any government in power. So that is the position post the judgment. And then came December 2023 when the government brought a law. What is the law? It is Chief Election Commissioners and Other Election Commissioners Appointment, Conditions of Service and Terms of Office Act of 2023. By virtue of this act, this committee composition, it is slightly changed. So what is the change? The CJI has been replaced by another member. So the other member would be a union cabinet to be nominated by the Prime Minister. So what is the current composition of the committee? The Prime Minister, a union cabinet minister who is again nominated by the Prime Minister, and thirdly, we have the leader of opposition in the Lok Sabha. तो इससे हम क्या देख पा रहे हैं कि लेट्स से अगर कोई कैंडिडेट है जिसका सपोर्ट हु इज बीइंग सपोर्टेड बाय द प्राइम मिनिस्टर एंड आल्सो बाय द यूनियन कैबिनेट, बट देयर इज एन ऑपोजिशन फ्रॉम द एंड ऑफ द लीडर ऑफ द ऑपोजिशन, so would that make any difference? No, right? Why? Because the majority is in the favor of the government only, the candidate who's backed by the government. So this is what has been challenged by the petitioners also before the Supreme Court. अब जैसे ही एक्ट पास हुआ एंड ये कमिटी की कॉम्पोजिशन चेंज करी गई, देयर वाज अ पेटिशन व्हिच केम बिफोर द सुप्रीम कोर्ट. द पेटिशनर इज डॉक्टर जया ठाकुर. She challenged the constitutionality of the selection committee, which is created under Section 7 of the Election Commission Act. In a petition, she argued and claimed that this Act of 2023, it directly contradicts the Supreme Court's judgment in case of Anup Baranwal by allowing the ruling party at the center to be the deciding factor. And therefore, the independence of the Election Commission, it is compromised, and so is the right to fair and free elections. Later on, another petitioner joined hands, and the another petitioner is the Association for Democratic Reforms. And now we need to understand कि यहाँ पर हो क्या रहा है. देखो, what is the ground of the petitioner's challenge? They are saying that this section is not constitutional, and they are claiming that since it is opposing, it is contradicting the Supreme Court's judgment, so therefore it should be struck down. तो लेट्स एग्जामिन कि पास्ट में हैज देयर बीन एनी इंस्टेंस जहां पे सुप्रीम कोर्ट ने किसी लॉ को स्ट्रक डाउन कर दिया इस ग्राउंड पे कि लेट्स से इट इज कॉन्ट्री टू द सुप्रीम कोर्ट्स जजमेंट. So there has been a couple of instances, and we take example of one of such instance. So in the past, the Supreme Court has struck down laws for being contrary to judgments it has passed. For instance, we go back to July 2021 when the court struck down the tribunal's reforms, Rationalization and Conditions of Service Ordinance 2021, for introducing several provisions regarding the service conditions of tribunal members that was similar to those which were struck down in November of 2020. Now, very interestingly, please note down these, events. So what happens is, on the petitioner, who is ADR, it put forth an application before the top court saying that you may kindly please list our, matter for a hearing on 15th of March. Now, why 15th of March? Because on the same date, the selection committee under the Election Commission Act, it was scheduled to meet for recommending appointments of 2 vacant election commissioners posts. So election commission में दो जो election commissioners होते हैं उन दोनों की पोस्ट जो है वो vacant थी और अब सिर्फ चीफ इलेक्शन कमिश्नर रह गए थे. तो जो 2 वेकेंट पोस्ट है उनके रिगार्डिंग नई रिकमेंडेशंस देने के लिए गवर्नमेंट ने सिलेक्शन कमिटी ने एक मीटिंग प्रपोज करी कि वी आर गोइंग टू मीट ऑन 15th of March. तो उसी दिन एडीआर चाह रही थी कि सुप्रीम कोर्ट इस मैटर को लिस्ट कर दे ताकि पहले कुछ एडजुडिकेशन आ जाए उससे पहले कि गवर्नमेंट कोई अपॉइंटमेंट्स कर दे. तो द इलेक्शन कमीशन इट हैड 2 vacancies. Why these 2 vacancies? Part of it is because there was a surprise resignation of the election commissioner Arun Goel on 9th of March. Now the election body, it was just left with only one member, the chief election commissioner, just days before the Lok Sabha election dates are expected to be announced. And हमें पता है कि हमारे जो elections होते हैं वो कितने massive scale पर होते हैं. So it becomes all the more important that our election conducting body itself is at most prepared. So on 15th of March, what happens is ADR filed an application seeking a stay on the appointments because the selection committee, so we missed one point here. See, what happened was the date was fixed as 15th of March, and on the same date, ADR approached the Supreme Court with an application saying that you place our matter for hearing. But very interestingly, the government, the selection committee met a day earlier, which is on 14th of March, and it appointed two election commissioners. Who are they? Gyanesh Kumar and Sukhbir Singh. आप ये names note down कर सकते हैं for the purpose of your exams. So a day earlier ये appointments हो गई. तो 15th March को ADR जो है it filed an application seeking the stay of these appointments. In its application, it stated and claimed that the central government, preempting the adjudication by this honorable court, It has convened a meeting of the selection committee on 14th March instead of doing it on 15th in order to render their earlier application infructuous by appointing election commissioners before the Supreme Court could determine the correct process of doing so. ADR, it also submitted that the leader of the opposition, Adhir Ranjan Chaudhary, he sought the names of the shortlisted candidates. However, none was provided to him in advance. So he was given very short time. This means that no time was given to all the members of the committee to consider the shortlisted names and to evaluate the competencies of the shortlisted candidates. Now let's see, how did the center respond to all of these allegations? So on the allegation of removing the judicial member, center का ये कहना था कि this is absolutely wrong and incorrect to say कि अगर कोई selection committee है जिसमें कोई judicial member नहीं है तो वो selection committee arbitrarily act करेगी. The selection committee is unconstitutional. So this is what the center has said, that the independence of election commission does not arise from the presence of a judicial member in the selection committee for the selection of these commissioners. To indicate that the selection committees without judicial members would invariably be biased, it is wholly incorrect. This is what the government said. Secondly, on the NGO's claim that the selection committee meeting was preponed on 14th of March just to preempt the Supreme Court's order the next day, the government said, this was the government's rebuttal, that the meeting had been rescheduled on 9th itself. अब 9th को क्या हुआ था? हमने देखा था, there was a resignation by one of the members. So the government said that this meeting was rescheduled on 9th itself in view of the resignation, and there was no attempt whatsoever to preempt the judicial process in any manner possible. About the leader of opposition not being given sufficient time to consider the candidacy of all of these members, all of the proposed candidates, the government said that the member of opposition getting the names too late, the list was handed to him under consideration on 13th of March, but the short list could not be provided as the search committee had not completed its process in its entirety by then. So having understood all of this, now let's go back and see what has happened before the Supreme Court now. So the Supreme Court, it has dismissed these applications which challenged the appointment of these two election commissioners. Who are they? Again, repeating the name. Retired IAS officers Gyanesh Kumar and Sukhbir Singh. So the Supreme Court has said that no, we are not going to interfere in these appointments. The Supreme Court also declines to stay the Chief Election Commissioner and other election commissioners appointment, conditions of service and term of Act 2023. So the court not only said that I'm not going to interfere in these appointments, it has also said that we are not going to stay the 2023 law. The division bench of Justices Sanjeev Khanna and Dipankar Datta said that staying these appointments at this very crucial point, when the Lok Sabha elections are just around the corner, it is going to create a lot of chaos and uncertainty. Further, so with respect to Section 7, जहां पर ये selection committee का गठन हुआ है, इसका creation हुआ है, the court refused to stay this particular section on the ground and saying that laws cannot be stayed unless under exceptional circumstances. अब ये बहुत ही important point है. I'm sure हमें पता है, we are aware of the presumption which is in favor of a law which is, let's say, enacted by the parliament or the state legislatures. So जब भी कोई law किसी भी कारण से challenge में है before the courts, so there is a presumption in favor of the constitutionality of that law. And if any person is claiming otherwise, which means अगर कोई person claim कर रहा है कि it is unconstitutional, then there has to be proof of existence of exceptional circumstances, and you have to prove that A, B, C, these are the grounds by which the provisions of the constitution are being violated, and therefore the court please strike down this particular law. So the Supreme Court said that stays on laws enacted by Parliament They are rare as they benefit from the presumption of constitutionality, which is a legal principle dictating that a law is valid unless proven that it violates the Constitution. In this regard, the bench made a reference to its earlier judgment, which goes back to 2000. The name of this case is Bhavish D. Parish versus Union of India, wherein it held, and I would like to quote, when considering an application for staying the operation of a piece of legislation, the courts must bear in mind that unless the provision is manifestly unjust or it is glaringly unconstitutional, the courts must show judicial restraint in staying the applicability of the same. Merely because the statute comes up for examination and some arguable point is raised, which persuades the court to consider the controversy, the legislative will, it should not be normally put under suspension pending such consideration. I hope this article will be helpful for your essay and interview. And now we proceed to the next segment. So now we proceed to the national news category, and this is the first update. India elected co-chair of ITU's Digital Innovation Board. Dr. Neeraj Mittal, please remember the name. He is the current Secretary of India's Department of Telecommunications. He led a very significant delegation to Geneva for strategic meetings at the ITU headquarters. ITU stands for International Telecommunication Union, and this happened, the delegation from 18th to 20th of March. The purpose of this alliance, it is to address significant unmet demands and needs of the ITU membership in case of an area of innovation, which was outlined in the Kigali Action Plan. Next up is an update about the new High Commissioner of New Zealand to India. Career diplomat Patrick John Rata, who is currently serving as the acting High Commissioner in Colombo, will be the next High Commissioner of New Zealand to India. And this appointment, it comes at a time when New Zealand has expressed strong interest in improving political, trade, economic, social, and cultural ties with India. Another important update, please remember the name of both these sportspersons. Veteran table tennis player and the current CWC champion, Sharath Kamal, he will be India's flag bearer at the 2024 Paris Olympic Games. Apart from him, legendary boxer MC MaryKom was appointed the chef de mission of the country's contingent. Another update in the sports category itself, Nayana James shines at the Indian OpenJumps competition. In the women's long jump event, at the third Indian OpenJumps competition, Nayana James from Kerala recorded a personal best, which secured her the gold medal. So what is the personal best? It is 6.67 meter in the long jump event. This is another important update. Now, with the Lok Sabha elections around the corner, this is an initiative by the Election Commission to help senior citizens and persons who have disability to the extent of 40%. So what is the initiative? Recently, in determined efforts to ensure accessibility and inclusivity in the electoral process, the Commission has introduced an app by the name of Saksham. What does this app do? See, persons who are, or voters who are above the age of 85 years and persons with disabilities with a 40% benchmark disability, they will be allowed to cast their votes from the comfort of their homes. So this is a very good initiative by the Election Commission, ताकि वो जो पूरा electoral process है, the process of casting votes, उसको inclusive बनाए, considering the needs of different groups within the society. Next up is also important update. Bina Agarwal and James Boyce, they've been awarded the first ever Global Inequality Research Award. Bina Agarwal and James Boyce, they've been awarded the first Global Inequality Research Award for their contributions in understanding global inequalities, specifically social and environmental inequalities. Now we come to the international segment. Mustafa Suleyman, the new face of Microsoft's AI division. Microsoft has named British AI pioneer Mustafa Suleyman as the head of its AI division. He was the co-founder of Google's DeepMind, will now report directly to the CEO of Microsoft, Satya Nadella. And this has brought us to the legal and last segment for today. Here we have an important update from the Juvenile Justice Act, and this is relevant for, let's say, the aspirants of Rajasthan Judiciary or other exams. I believe up to वैसे भी this act has been included in a lot of exams, a lot of judiciary exams. So please pay attention to it. Let's go and read this para first. ये हमें better clarity देगा to understand what the Supreme Court has held. So the court said that the question of whether there is need for trial of accused child as an adult or as a juvenile under Section 19 of the JJ Act, the Juvenile Justice Act, it could only be decided based on the preliminary assessment which is conducted by the Juvenile Justice Board under Section 15 of the JJ Act, which ascertains whether a child who has completed or is above the age of 16 years has the mental and the physical capacity to commit the heinous crime which is allegedly committed by the child in conflict with law. So essentially court ने ये कहा है कि ये जो question है कि whether there is a need for trial of such child as an adult or as a juvenile, how do we try the child who is above 16 years of age and has committed a heinous crime? So do we try him as an adult? Do we try him as a juvenile? इसका जो decision है, it has to be based on the assessment, on the preliminary assessment which has been conducted by the Juvenile Justice Board. The accused who was a child in conflict with law at the time of commission of an offense cannot be tried by the trial court but only by the children court as is mandated by Section 90. So therefore, recently the Supreme Court held that conviction of the accused child who was a child in conflict with law cannot be sustained. You cannot hold such conviction as valid unless this condition is met, which is that the preliminary assessment to ascertain the physical and the mental capacity of the child to commit the crime and the need to try the child as an adult or as a juvenile, it was adhered to as the mandatory requirements under the Juvenile Justice Act 2015, especially in Section 19 and Section 15 for that matter. The name of this case is Tirumurthy versus State, represented by Inspector of Police. And this has brought us to an end of TNA. The quiz link is made available in the description, and the resource material, which is used in the TNA, and the other material that LawSikho curates for access for free, they can be availed by all of you by joining our Telegram channel. And for the same, you may click on the link which is given in the description, or you may scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us and have a wonderful day ahead.